Blood Money, article by Anna von Reitz, Part 11. Additional issues for the International Court of Justice, Counterfeiting. One way to look at the current situation is that we have taken possession of the labor bonds issued in our names by the DTC, which represented the U.S. debt, and which on the flip side, from our perspective, establishes the American credit. Those who have been following the logic already know that it is impossible for such a debt to exist without an equal generation of credit. Each existing Federal Reserve note of any denomination has a serial number, and that serial number is attached specifically to the life estate of an American. The labor bonds were the basis of the issuance of that currency as a debt owed by the municipal United States, and that debt continues until it is offset. The only way to offset it is for it to be redeemed. Someone has to walk into a bank and exchange it for a new currency, which will be based on spending down the prepaid credit. That is, the new currency will be a credit certificate, not a debt note. As the new bills go into circulation, the debt is naturally retired and the old Federal Reserve notes are destroyed. We plan on doing something very simple, leaving the president's faces on the bills so that people are not too startled by the change, and replacing the reverse side image of the currency with our American bison symbol, something like this. The exchange rate will be 1 for 1, so that nobody feels cheated. As this currency is backed with prepaid credit, there is no longer any implication of debt incurred by the user. And as it is being issued by the actual government and not a consortium of private banks, it will be a fully secured public script. The effect of the offset on the world economy and the average American family both will be swift and positive, but also gradual enough to avert chaos. There will be no need to worry about rushing to exchange Federal Reserve notes for American certificates. There remain numerous concerns, and among them, one of the chief concerns is counterfeiting and failure to dispose of redeemed Federal Reserve notes. Mr. Obama set up a worldwide counterfeiting operation based in China, Thailand, and various other foreign countries, and actually sent our printing presses, specialty papers, and inks and engraving plates to these countries so that they could print their own supplies of Federal Reserve notes at will. Of course, the serial numbers are faked and or duplicated, but otherwise these bills look absolutely authentic. This presents the specter of having an endless supply of new debt notes that these foreign enterprises can present for exchange against our credit certificates, and significantly increases the cost of detection and disposal. We propose that those responsible for this situation, the Queen's government and the government of Westminster, be held accountable, and that we should be reimbursed for these counterfeit Federal Reserve notes along with the cost of detecting and disposing of them. This particular problem, like so much else, would not exist except for their choices and actions. Furthermore, the disposal of redeemed Federal Reserve notes cannot be entrusted to the usual parties, the Secret Service, Treasury agents, and Federal Reserve banks, since the temptation would be to recirculate the bills instead of destroying them. We should be reimbursed for the entire cost of setting up our own double or triple-walled disposal system. Federal Reserve notes have been used as the domestic currency of this country as part of the administration of the monetary system by the U.S. military since 1913. As the Territorial Congress is not authorized to issue money and is obliged to function on credit only, a debt credit system had to be adopted with the municipal United States and its citizenry held to be the debtors, and the Americans targeted as the creditors, with the territorial U.S. citizens left cozily in the middle as the ultimate arbiters. Of course, nobody told us, the Americans, about any of this. The various purported changes in our political status created by unconscionable contracts and registration processes foisted off on us as babies were undisclosed and used to redefine Americans as federal dual citizens, deemed to be obligated both as territorial U.S. citizens and municipal citizens of the United States. In other words, our erstwhile foreign employees redefined us as anything and everything but what we actually are, the long-lost Americans. And now, like the American bison and the American chestnut tree, we are back home. Approximately half of our purloined estate has been returned to us by the Pope. This is not exactly a favor, as the relief of the American credit being applied also means the offset of the municipal debt. And while that releases Americans from bondage, there remains the issue that most of us were not actually municipal citizenry to begin with, and never were. We didn't owe any war reparations, and were stuck for it anyway. The ownership of the municipal corporations and the territorial state-of-state corporations that have been chartered in our names must also be settled. As this was all predicated on a sesta-que-vie basis following the Second World War, we propose that all those corporations be returned to American control and rechartered under our public law, without any debt or encumbrance attached. We are being approached on all sides by conventional commercial bankers hungry for corporate medium-term notes, thinking that our labor bonds are bonds that they can reissue as monetized securities. They still aren't wrapping their heads around the concept that these bonds have already been issued and are matured and will be gradually cashed out. Think of savings bonds. They are issued, they are kept for a specific period of time, they mature at a final value, they are cashed out. The labor bonds are similar. They are issued, they mature, they are cashed out as bearer bonds. So there is no further securitization or monetization involved. None would be possible anyway, as our public law forbids the securitization of living flesh, a fact that will shortly be brought home for those who have presumed to trade upon our land assets as if they belonged to a foreign nation. The double-ended impersonation scheme that has kept Americans enslaved to foreign governments since the end of the so-called Civil War is at an end. The international banking community will have to readjust its thinking, its practices, and its assumptions of debt to fit the facts, and so will the courts. The pertinent maxim of law impacting both the Roman civil law and the law of admiralty is, fiction yields to truth. Where truth is, fiction of law does not exist. Between them, the Queen's government and the government of Westminster owe us, the Americans, the return of all the land titles they presume to exist on the basis of their unconscionable registration processes and their assumptions about our individual political statuses, and also the return of all our purloined and removed gold and silver assets, which the U.S. Navy began to transport offshore in the 1880s for safekeeping in the Philippines, Indonesia, and other ports of call. This offshoring and cashiering of our gold and silver reserves has prevented the re-establishment of sane commodity value standards throughout the world, and has expedited the lawless and unaccountable commodity rigging, including the manipulation of international currency commodities that we have already discussed. It is apparent to any thinking man that this entire criminal boondoggle, which has occurred in gross breach of trust and commercial service contract, is more than sufficient cause for the high courts and international and global jurisdiction to take action in our favor and to require the return of all our purloined assets, including our Title IV flag, which was loaned to our treaty partners for their use in the discharge of their delegated powers, that is, duties for which they have been well compensated, and which was lost to pirates during the year 2000 vacating of the United States municipal capital. If we loan our lawnmower to our employee so that he can mow our lawn, and a robber takes it, it is still our lawnmower. The pertinent maxim of law is, possession by pirates does not change ownership. In the same way, our Title IV flag has been seized upon by pirates and is subject to recapture under both law merchant and admiralty law. We understand that the pirate in question, a Mr. Russell Gould, went to the Vatican and cut a deal, claiming that he was the rightful owner of our Title IV flag. We strenuously object to these agreements made in our presumed absence and dispense with them as the actual owners of the flag in question. We consider this another form of counterfeiting and attempted identity theft, which must be universally opposed.